Now I would like to welcome Marit Hansen, Data Protection Commissioner of Schleswig-Holstein in Germany. And it's a very interesting topic, the Clark Kent of the GDPR. We are looking forward.
Thank you very much. It's always good to have this rocky music, not really rocky, but okay. So I tested this presentation not fully. It's because I adhered to the rules that I should use this template, and therefore I seem to be the only one. But anyhow, I tested the word Clark Kent with not the result that I expected to have, and therefore I have to test it again here. Who knows who Clark Kent is? Very few are not raising the hand, and I still, as a teaser, I want to show you. Probably now everybody remembers former times, Christopher Reeves here, but there are also remakes, of course. So Clark Kent is the civil identity of Superman, and you are better than the German test group, I have to say. What about the GDPR now? So is the Article 25 something we can work or should work with? Is it even the superhero power there involved? Because when we saw from Alexander the statistics on Article 25, there was mainly no enforcement yet. And so one of those many articles that were mentioned here. So I want to look together with you into Article 25, only to remember, because you have, of course, read every article and haven't skipped that one, but looking again, looking at conditions, looking at opportunities, then concentrating on the defaults, the second part of Article 25, then having a few glimpses on how to put that into practice, and then we come back to Clark Kent. And you can decide whether this is the superhero article or not. My background is Data Protection Commission of Schleswig-Holstein. For 4 years now, I'm the commissioner. Before that, 8 years, the deputy commissioner. Schleswig-Holstein was mentioned several times today with very good pronunciation. I acknowledge that very much. Because of our Wirtschaftsakademie Schleswig-Holstein ECJ case. This year is also about something where the design plays a big role. Data protection by design and by default. Article 25, quite early, before 32, with the security by design. And if we only look into the first paragraph, it's really not attractive to read that. But let's boil down to some essentials. Who is responsible? You have read the GDPR, and you know always it's the controller and the processor. Here it's, in fact, only the controller. And there can be indirect effects on the processors, because they are asked to provide the necessary design, and also the producers. There's only one recital for Article 25. This is recital 78. Usually you have some more to read. And this is where producers should be encouraged to do stuff in data protection by design and by default. Encouragement is, well, not a really legal term where we are totally sure what this means. I argue when I discuss with my government in Schleswig-Holstein, you can encourage, for example, by promoting something, by giving money, by investing, by procurement, or also in one case we probably get some easier taxes for people who are in an association using some by design technologies. What should the controller do? Implementing the right measures. Usually many people think it's about, okay, so we have the car, and now we have to, let's say, seatbelts. We have to put seatbelts on top of this car design. This is, again, something where we have the technological and organizational measures. It's not necessarily something you put on top or at the end of the process, but it's really something where you should implement that from the beginning. And therefore, I'm not totally glad to have this term measures if it's something where it's baked into the functionality already. But okay, let's skip that. Keep in mind, it's not something where we only put some measures after the fact, but implementing really that stuff. And what should be implemented? There are some examples, the data protection principles. So everything which is laid down in Article 5. You know that there are some tensions. You cannot maximize all the data protection principles, and there are also other effects. And also to integrate the safeguards and that is into the processing in order to meet the requirements of this regulation. So something where even the provision Article 25 itself should be supported by Article 25. We have some recursion inside, which makes sense because even the implementation platforms, those things that are used by implementers could profit, of course, from Article 25 ideas. So that it's one step further. And to protect the rights of data subjects. So this says, use the data protection principles and put them into your systems, data processing, Article 5. Put everything of the GDPR into the system, yes, including Article 5. And the rights of the subjects, yes, this was already there. So really pressing this and meaning, well, by design. As we knew that beforehand, that we knew data protection or privacy by design as coined from different people, like, for example, Anke Wukian, implement data protection. And when, this is also no news, at the time of the determination of the means and throughout the processing. So always throughout the full life cycle. When you decide what you want to do, with whom, with what technologies, means, processes you want to do that, apply that already. And also don't stop applying it. That means also to reiterate thinking of that. So this is something we knew already, had some guidelines, some nice ideas. Now it's a law. But so this should have looked different. Think of putting these Article 24, 32 on the left side. What are the conditions? And if you read the text, and this is, I think, the part that is so unattractive, it begins with taking into account the state of the art, the cost of implementation, and a very long sentence, what you always have to take into account. Meaning you have to do that, you have to check state of the art, cost of implementation, nature, scope, context, and purpose of processing, and the risk for the rights and freedoms of natural persons. So this is, before you implement anything, you take into account so many conditions. Is this something new? No, it's not. In the 1995 directive, old stuff, we had Article 17 on security, and in principle the same conditions applied there. Although nobody protested against. We don't know what the state of the art is. Now everybody is doing that, but it's nothing new. So we had already some provisions where it was clear you have to do something and build in something more. The security perspective, yes. But we all know that this has also failed. Now we see this is also copy-pasted in Article 32, the security by design or security article. It begins with the same wording. We have the same conditions. But this means if a data controller asks me, should we do that or not, we think the cost of implementation is too high. Then this must not be an excuse, because in Article 24 we have already, therefore this blue line here, something with nature, scope, context, purpose, and the risks. So if the risk is high, and I cannot remedy, I cannot mitigate them because the cost of implementation is more that I can afford, then probably I must not do the data processing anyway. So there must not be any excuses if it's risky risky data processing. But of course, it does not mean, because now people say, in principle, it's not only possible to have this username password thing or some biometric thing or two-factor authentication thing, but let's take four-factor authentication. This is possible. Yes, it's possible. But is it adequate because of the risk? Is it adequate because of, well, convenience? We have to see that it's really mainly about the risk and the data processing, but the other things, state of the art or cost of implementation, have to be taken into account. So only that you're aware of, look into Article 24 because of the accountability and responsibility rules. There are no excuses for critical data processing if you don't do something against the risk or having something implemented to mitigate the risk, then it's probably not okay. So we see that again, and therefore, it's not something where there are so many excuses, but really something where minimum requirements or also maximum boundaries can be defined. Can be defined means Article 25 does not define itself directly what you have to do. There's no word like two-factor authentication. There's one measure mentioned, pseudonymization, but also pseudonymization is not working all the time. Or do you think here the participant list is available in a pseudonymized version? Probably not, and it does not make sense, usually. Here we see that so many ideas are there in the Article 25, but have to be well, more specific if we really want to work with that. So I agree. Still, this is something where fines are possible, even if there are very few fines yet. I heard about one, according to, on the basis of Article 25. It's the small amount of fine only. The administrative fine up to 10 million euros or 2% of the turnover of the preceding financial year. But usually, it's not only an infringement of Article 25 if we become aware of some infringements. Usually, it's a combination of several articles which and data protection principles that can and should be mentioned if we are setting a fine. And you know the fine for Article 5, so the data protection principles, is the big fine. It's 20 million euros and 4%. So only that it's not necessarily something where this is the one thing which decides on the fine or not. And I believe that although the fines are the most shocking thing, and the media is still very much working with that, and people argue, you have to hire me, otherwise you have to pay fines or so, something like that. There are stronger powers than having a fine. A fine is something ex post, so only after the fact, some controllers and processors perhaps have to pay something. But we see that there are much stronger powers, for example, if we can issue orders to bring processing operations into compliance with the GDPR. And even a limitation or a ban of processing can be adequate. Usually we will check very, very diligently beforehand whether we issue that or not, but still this may influence the data processing much more than having to pay a fine. Also, if you do something for Article 25, this can be good for you if there is still an incident and you have to pay a fine or may have to pay a fine, because if you can prove, but I did already follow the rules of Article 25 and 32, then usually it can be used in a way to reduce that, because you had taken measures, and probably if they were state-of-the-art, perhaps nobody could expect this damage, this risk that has been exercised. So what about the opportunities? Of course, it's about preventing risks. It's about minimizing damages, so if damages happen, that the effect is not so much. And also about resilience. You see here a nice stilt house from my area, Schleswig-Holstein. It's not the Baltic Sea side where I come from, but the Northern Sea. And these stilts have to be built into the design process, of course. There are not so many people living there. There's sometimes some museums or a cafe or something. Still, they're at the beach, and the beach may be flooded. And therefore, this is a good mechanism to take the risks, and they can be there for hundreds of years, perhaps. They are already quite old. Very nice to see, nice to photograph, but it makes sense. And you can see that the design has been altered. We don't expect to see that here in the interior of a city. Article 25 is also good for accountability and taking over responsibility, even if you decide that you have not to do anything because everything is already fine. You can document that, and it's always good to have that documented in a way where you also can revisit your decisions perhaps 1 year later, learn from experiences, and having checked that, perhaps similarly to Article 32, the security mechanisms, usually the processes for that are existent in at least the bigger companies and organizations. Article 25, many people don't know, it can be kind of a twin procedure that you use both and revisit the possibilities. Can I optimize my data processing according to data processing by design, and to document that. And in principle, this is now something where it's obvious that a data controller, although those are those who are responsible to take actions here, that they are limited in what they can do unless they are developing their systems by themselves. Because very often the possibilities to design something are limited by producers, or the processor decides on what is happening, and therefore we need to have more requests for data protection by design possibilities. I think that the change of the ecosystem may be even more prominent if we take seriously Article 25 with the second paragraph, and therefore we come here to the power of defaults. You see here a shorter text. I think it's mostly half of the text because there are no conditions. It does not begin with taking into account. It's not about taking into account anything. It's about doing something. It's a very without any compromise. You have to do something here. Again, the controller. Again, technical and organizational measures. But it now concentrates on one principle, on one thing is mainly regarding necessity, which is quite boring because we knew that already, that the necessity principle has to be fulfilled. There's a purpose, and we only are allowed to use the data as much as so. So it's already there, but it's not so much put into practice concerning the data processing itself. That, for example, temporary files are very often not regarded as we should take care of those because they're gone after some time. Yes, after some time. But what is really necessary, it's totally different from what is the idea, whether I need the data or not, and the real processing, where many more hops can be involved, data transfers, storage at different sites and different jurisdictions, for example. So the technical mapping of the idea, what is necessary or not, is not automatically done. And if you have no idea how technology works, then you probably wouldn't think about additional risks. Again, I repeat, there are no conditions. You have to meet Article 25 with the paragraph 2. And the default, doing something by default, is the starting point. So it does not mean that it has to stay the way. It has to stay as it is. The individuals, for example, may change that if they are convinced they want to issue more, disclose more data, or want to give consent for other data processing, for example. But still, it has to begin with a data protection friendly, coming to a necessity, starting point. Now, the necessity principle is explained further in this paragraph here. It's about the amount of personal data. I think this is totally clear, but also the extent of processing. So whether you do more or less with the data, do additional profiling, for example, interpret also additional information which may be embedded, finding out about the data which is not necessary for that purpose. So this would be limited as well. The period of storage also, to have it as short as possible. Again, we have that in the principles. And what I think is very interesting and has not been anywhere beforehand is the accessibility. And not in the sense of inclusion, accessible technologies, but accessibility of personal data. And it can be the debate whether it's better to store something locally and process it locally, or having it somewhere at providers in the cloud and so on. It does not mean that local is always better. But at least you have to because there might be an unsecure system at the local side, and you want to control it better if there's some protected devices or protected processors. But putting it somewhere where you don't know who may, in addition, access the data, this is probably not so good for the limitation of accessibility. So I don't think this has been understood very well right now. And it's also, we have not gotten many, I think we haven't gotten any complaint right now for data protection by default. Some people are asking questions, but haven't started to complain. So if we want to put it into practice, I put it here three main categories: the data minimization, transparency, and this data subject rights. And only to mention a few to give a little bit a glimpse of that. We have the pseudonymization and anonymization possibilities. We can look into forms. Is it really about only the necessary data? That it's clearly what to enter and what not, about uploading information and stripping metadata, which sometimes is not happening, and we see so many interesting metadata in photos, in Word documents or so, which should not be uploaded. Encryption could be wired in instead of having a nuisance to do that, as far as this is possible with the key exchanging. And what I also see belongs into that criteria here is the unlinkability. Use different identifiers if possible, and therefore it's always very risk minimizing if a data collection, if there's a breach on a data collection, and then the central identifiers, it could be your social security number, are out in the wild instead of only derived identifiers specific for the purpose and specific for the domains. Attribute-based credentials are one mechanism which can be used. We have in Germany for about 10 years our eID card, which has some similar possibilities there. It's kind of privacy enhancing. Still, it's not flying because there are so few services using that. But the debate will start: what is here state of the art and what's not. Transparency, I think it's very difficult to inform about your data processing in the easy language that it's still everything is correct and understandable. But this will be a challenge to be better in that, especially because the GDPR is not that easily written itself. The multi-layered approach is quite good. Icons will come and will be standardized. Think also about machine readability. Of course, data controllers can wait a little bit more how this will be standardized, but I think good proposals are already welcome. Dashboards are good for seeing an overview, what is there about your data, and perhaps also for the next step if you want to correct or want to delete something. And also if you want to, more the security perspective, want to be aware of what is happening. It's not always about storing nothing or having no logs or so. Very often you have to have logs, log files, to know what is happening, and then to make sure that there is no breach, or that if there's a breach, if there's an attack, that you can react appropriately. This support for access rights is similar for the data subject rights, where you also can support data subjects much better. The requirements of the GDPR are quite strong, I think, saying within 1 month you have to inform about the data there, rectify the data, delete the data, and so on. It means you have to implement the possibility of the subject rights already if you design the systems, and knowing where the data are and knowing how to deal with that if you got this request. The complaint handling is also very important, not only because it may be a data protection issue, but also because very often the complaint to the data protection supervisory authority is not because people really are so interested in data protection, but sometimes they are so annoyed about what has happened to them, including data protection infringements. And therefore, if you have a good, easy handling system and it can de-escalate such complaints in your organization, then the likelihood that the supervisory authority will have these persons who are very annoyed, yes, that will be much more unlikely. It's also good to think about sensors and deactivating sensors, the possibility of deactivating something and stop data processing. I think this is often missed. And of course, then the requirements will be make sure if you deactivate your sensors in your autonomous car, then some more things will change. But still, it has to be taken into account. It's not always about accepting that perhaps we are monitored and cannot do anything about that. So now I come to the conclusion, or perhaps you come to the conclusion, is it now the potential of a superhero article or not? The underdog, the superhero. Right now, it's still the Clark Kent and the cape is not visible. But perhaps we can meet in 5 years. I wouldn't say 1 year time, because it may need a little bit longer to go into the, where does he get the cape, the phone cell, or so, where phone booth and getting redressed here. So right now we see only baby steps. Article 32 is also not so well implemented, but much better than Article 25. We need to bridge the gap between research and practice, because in research we see so many excellent solutions, but often they are not state-of-the-art yet. We need maturity requirements, how to find out whether this is already something in the wild where you can use or buy it or implement that or not. There are many proposals already, but we have to push it forward. We cannot rely only on controllers or the controllers on themselves, but ask for those things that are necessary. Also think about, for example, your phone system for your employees, your cars for employees, your smart electricity metering systems that can also be monitored, can be used to monitor employees, that as a controller, you will have the responsibility to minimize that as well with the data processing. And what will also will be happening, I hope in the next year already, the certification, because this is the last paragraph of Article 25. The certification will probably be also valid to help to find out whether this is now a good solution or not. And therefore, we need powerful best practices for Article 25. You can read on. I assume that the slides will be made public, otherwise I can make them public. And I see huge potential. We are not there. It's still the Clark Kent time, and we are here, perhaps all Clark Kents and Lois Lanes. But anyhow, together, we can make it fly. Thank you very much.
Thank you, Marit. I think we have time for a question or two. We have a question. Do we also have? Okay, I get a second chance.
All right. I have a more practical question. It's a bit difficult to phrase, so I'll take it slowly. Let's say controller A is a big company with a lot of employees, and then there's controller B, who's a health provider. So we have two controllers. And each one of them is responsible for the data being processed, right? So if controller A wants to use controller B to get the health service for the employees, we know that controller B is responsible, but as controller A, we still would like to make sure that controller B is compliant to GDPR. So we do a very good due diligence at the beginning, checking all the points you mentioned in Article 25. But contractually, after the beginning, then there will be, let's say, 5 years of service or 2 years of service. We are not contractually able to go in and audit them, because if we do that, then technically we're trying to make them a processor. Do you understand? Mm-hmm. And because we said before, what's in the contract doesn't really matter. It's the action that counts. So what's your advice on what kind of health providers do you understand? Like if it's two separate controllers, but controller A still cares about the data, although controller B is legally responsible. Does it make sense?
Okay, so in principle, it's not necessary that there's a relation, because there are two different controllers, yes, but they use the same data, employee health data, for the other person, because usually there's one solution where we say it may be joint controllership, where still the arrangements according to Article 26 can be negotiated, and there's free contractual things, even if they are not bound to do that. But for example, if there's now a data breach with controller B, controller A wants to get out of the contract or to change something, and therefore I don't think that you cannot put on top saying, please make sure each year and that you are compliant with the GDPR, not only 25, of course. And it would be the relationship that we prove each other that it's okay. Right now we have no certification. With the certification, it may be something which could be helpful, but probably we don't need the certification instrument saying, we want these data, you get these data, but of course you have to be GDPR compliant. If you don't think that it is, perhaps you can issue a complaint, for example. Yeah.
I'm thinking also that it could be like very good to store the documentation from the due diligence at the beginning to help controller A if something happens with controller B. Yeah. Yeah. So, but that's the only.
I'm not sure how to answer that. It seems to be a trick question, yeah, because you have something in mind.
That's all, actually. Yeah. But yeah, thank you. That actually helps. Yeah.
Thank you so much. Thank you, Marit.
Thank you.